Good morning, everyone, and welcome to our online seminar for Safety and Adverse Events under MoCRA. This online seminar will focus on the repercussions of the Modernization of Cosmetics Regulation Act of 2022, also known as MoCRA, and the changes in consumer product regulations that could impact all cosmetics sold within the U.S. market. While implementation has already started, different aspects of the legislation will be gradually rolled out over the next few years. Today, we will help you interpret the MoCRA regulations around safety substantiation and adverse events with our experts Barry Reese and Jacqueline Belomo. I am Anna Benavente, Director of Product, Labeling, and Ingredient Review at Registrar Corp, and am pleased to be your moderator today. As we begin, I'd like to go over the topics that our experts will cover today. As I just mentioned, we will be focusing on safety and adverse events under MoCRA. We will begin with the key requirements and key terms under the new law. Understanding these is very important as they impact which requirements will apply to which companies and which products. We will then discuss the types of safety testing you should consider to ensure that your company is meeting MoCRA's requirements for what constitutes a safe cosmetic and the mandates for safety substantiation. Additional guidelines regarding FDA's new enforcement authorities and what you should do to get ready for the compliance dates of the new rules will follow. From there, we will move to the new requirements enacted under MoCRA related to adverse event record keeping and serious adverse event reporting requirements. We'll go into detail about what constitutes adverse events under MoCRA and what companies must do to adequately prepare to comply with the new law. We'll wrap up with a question and answer session. As we progress through the webinar, you are welcome to put questions in the chat box that we will address at the conclusion of our presentation. We are very fortunate to have as our first speaker, Barry Reese, the General Manager of the Beauty and Personal Care Division of the Americas at ALS Global. Barry has both a bachelor's and master's degree in microbiology, as well as an MBA and more than 30 years experience in the cosmetic and personal care industry. Barry began his career in claims substantiation with Mary Kay and was responsible for establishing RCTS's instrumental expert grading, safety substantiation, and consumer perception claims program. We thank Barry for generously providing us with his expertise today. For those who are not familiar, ALS is a global leader in the clinical testing of cosmetics, personal care products, over-the-counter products, and topical drugs. ALS has 5 clinical sites in the US and 4 in Latin America that can evaluate the safety and efficacy of products designed to go on the skin, hair, and intimate areas. Additionally, with large chemistry, analytical, and stability laboratories in California and in Sao Paulo, Brazil, ALS can handle most requests for chemistry, microbiological, and stability testing. ALS performs over 7,000 clinical trials a year and is a recognized leader in the clinical testing industry. Our second speaker is another industry expert that we are fortunate to have with us today. Jacqueline Belomo has over a decade of experience in technical formulation, regulatory compliance, product development, and brand management. She's extremely knowledgeable, having a bachelor's degree in chemistry, master's degrees in cosmetic science and regulatory affairs, and a master's of business administration. She's been active in many committees across industry and professional organizations to assist companies in achieving compliance, including those dedicated to educating cosmetic companies about the new MoCRA requirements. We thank her for her participation today. Jacqueline is currently the Director of Cosmetic Science and Regulatory Affairs at Registrar Corp. Registrar Corp is a leading provider of government compliance services and was founded in 2003. We offer cosmetic services such as registration and other MoCRA requirements, label and ingredient review, assistance with California Safe Cosmetics Program, and more. We also offer an innovative software solution to empower companies to accelerate product development and streamline compliance operations, Cosmetry by Registrar Corp. And with that, I will turn it over to Barry Reese to begin our presentation.
Thank you, Anne. I really appreciate the introduction, and welcome to everyone who's participating in today's webinar. I'd like to thank you for taking time out of your day to listen to both Jacqueline and I discuss some of the key requirements or key aspects of MoCRA. As many of you know, MoCRA was signed into law in the end of December and became December of 2022, became effective in December of 2023 last year. It's the first major piece of legislation that has been enacted since 1938, when the Food, Drug, and Cosmetic Act was enacted, and that's been over 85 years. So this has been kind of a sea change in the cosmetic and personal care industry. There are some key requirements of the new law that we'll go through. As you see here, the first one is that there will need to be a responsible person, which has been defined as a manufacturer, packer, or distributor of cosmetic product, whose name appears on the label of such product. The responsible person must submit to the FDA a cosmetic product listing of each product marketed in the U.S. Products marketed after 2023 will need to be listed within 120 days. And then updates can be submitted annually. There will also be a need to have serious adverse event reporting. Jacqueline will go more into this, but just as a highlight, serious adverse events will need to be reported to the FDA within 15 business days after receiving the report of the adverse event. And the records will need to be maintained for 6 years for most companies. Smaller businesses, there have been provisions for retaining the information for only 3 years. You'll see from the next slide some of the other key requirements of the new law is that the responsible person shall ensure and maintain records supporting that there is adequate safety substantiation of their cosmetic products. This is important, and this is one of the key topics that we'll talk about is helping you substantiate the safety of your product. The requirement of MoCRA also allows the FDA access to all records related to the manufacturing and safety substantiation of cosmetic products, and provides for mandatory recall authority if the responsible person does not voluntarily stop selling or distributing the product. And this is part of what's going on now with registering your product and registering the ingredients. Is the FDA is now going to have a window into what products are being sold, and they'll have the ability to then ask for this type of information from manufacturer. Domestic contact information such as address, phone number, website, or email on the label of each product through which the responsible party can receive AE reports is going to be required. And this will be important because this is how you're going to be able to capture that information. There's some key terms we need to be familiar with. One is substantiation of safety. This is coming straight out of the legislation. A responsible person for a cosmetic product shall ensure and maintain that there is adequate substantiation of safety of such cosmetic product. Well, they don't really define what adequate safety information is. So the next line says the term adequate safety substantiation means tests or studies, research, analyses, or other evidence of information that is considered among experts qualified by scientific training and experience to evaluate the safety of cosmetic products and their ingredients, sufficient to support a reasonable certainty that a cosmetic product is safe. What is safe? According to the legislation, safe means that the cosmetic product, including any ingredient thereof, is not injurious to users under the conditions of use prescribed in the labeling thereof, or under conditions of use as is customary or usual. And this is critical because what this means that at the end of the day, we really need to evaluate the product under the conditions for use. That is, how are you instructing the consumer to use your product? There are some tests that are designed to look at various responses to the skin, but they're not designed to be tested under conditions for use. They are aggressive conditions designed to look for irritation or allergy, but they don't allow you to assess how the product interacts with the skin when used under normal conditions. So what I'd like to do is I'd like to go ahead and when we go to the next group of slides, we'll talk about safety substantiation. So there are different types. I just want to again mention the safe because these two bullet points or these two items are going to be critical to guiding you to help produce your safety dossier or safety package. So again, the responsible person for a cosmetic product should maintain or is required to maintain that there is adequate substantiation of safety of such cosmetic product. And the term safe again means under the conditions of use prescribed in the labeling thereof, the product has been evaluated. Uh, the safety substantiation for the responsible person, we need to make sure that the manufacturers can use different types of data. You can use relevant safety data that is already available to support the safety of the products. Animal testing is not required. It is important, however, that the data used to support the safety are derived from scientifically sound and robust methods. And what this means is that in a in a situation where you're looking to substantiate your product, you need to ask the labs that you're working with what best practices are, so that you can adhere to what is considered standard in the industry. For example, it's probably not going to be considered standard if you gave it to 10 of your friends and you had them respond back to you that, hey, everything is good. That's probably not going to be considered scientifically sound or robust. It really needs to be done under controlled conditions in a clinical setting. And there are different types of safety testing to consider. And we'll talk first about the HRIPT because that's probably the one test that most people are familiar with. It has a place in safety assessment of a product. It in and of itself does not lend itself to the robustness that MoCRA is indicating because it does not allow for the assessment of product under normal use conditions. This type of test is performed under patch test conditions. It's called a patch test, human repeat incell patch test, and it's designed to have the product applied to a patch or something considered like a Band-Aid or a bandage. And it's applied to between 50 and 200 people over the course of approximately 3 weeks. Well, there's a rest phase where there are no applications. Then there's a challenge phase where you typically apply the patch to a virgin, unpatched site and you look to see if there's any type of induction in allergy associated with the application of the product over the 3-week period. The study can be performed on individuals with sensitive skin if that's important for you. The data is typically reviewed by a dermatologist to be able to get the assessment of whether or not your product induced an allergic type reaction. And ALS performs these types of studies on a weekly basis. But again, it's part of the dossier, but we wouldn't say that it's complete because, again, one of the definitions we talked about is that the legislation calls out that in order for something to be considered safe, we need to evaluate it under the conditions that the product is designed to be used under. So if it's a body or if it's a body product or a face product, it needs to be designed the study needs to be designed to look at the product under those conditions, whether it's using 3 times a week, 5 times a week, 14 times a week, whatever the situation is. But there are other types of tests you could consider in addition to the HRIPT. And if we look on the next slide, you'll see that in-use testing is a valuable tool. So the next slide talks about the advantages of testing under in-use conditions. What this allows you to do, it allows there to be both subjective and objective tolerance data captured. One of the things about a patch test, it really doesn't allow you to get much information about subjective responses, such as burning, stinging, itching, things that you can't, a physician can't see, but a subject or a participant may be able to share with you. The use test can be performed under the supervision of physicians, so it allows for medical professionals to assess how the product is performing when applied to the skin under normal use conditions. The studies typically involve around 30 to 50 participants. The length of the study really varies, and it depends on the frequency of use. Products that are probably not used very frequently, let's say 3 times a week, you may want to do a 4-week study so you maximize exposure. Whereas if studies are used twice daily, then 14 days may be enough. That would be about 28 exposures, and that would give you enough information to at least determine if there's any objective or subjective responses associated with the product that might be untoward or provide information that the products may not be safe for their intended use. There are different types of in-use testing, and as we go to the next slide, we'll talk about dermatological testing, which is one of the most common ones. It's used on a number of different types of products. Those are listed there on the right. And what this study is designed to do is help determine the in-use safety of topically applied products under normal use conditions. It can be applied to the legs, the arms, the face, the body. And typically, a board certified physician, a dermatologist, will evaluate the subject, and we will also ask the subject for their subjective responses. We want to understand not only if the physician is seeing any type of redness or dryness or edema, but are the subjects experiencing anything that would be untoward or problematic, such as burning or itching? Is it chronic? Is it transient? Is it stinging? These things may not be something that you, as when you were developing the product, had any indication that this would be an issue, and it could mean that your product is not being tolerated well. If people don't want to use your product because it's causing a burning or itching sensation, that's something that you'll need to know. And if they may, and Jacqueline will talk about this, they may end up calling you and reporting it as an adverse event. So by doing this type of testing, you kind of have a window into what you might be expecting if you do decide to move forward, because the burning might be transient. And again, transient type of AEs are not necessarily what the FDA is looking for, but they may be helpful for you to show that you've done a robust test to be able to capture the type of tolerability data that can help you assess the safety of your product. Again, these types of tests can be done on individuals with self-assessed sensitive skin to help you target a population of people that will be using your product if you're trying to make the claim safe for sensitive skin. If we move to the next slide, there's also other types of safety and use testing, and another very common one is ophthalmological safety and use testing. And this is a really important one because these are designed to look at the tolerability of products applied to the eye area. So these are the types of products that you see there listed on the right, like mascaras, eyeshadows, eyeliners, lash extensions, things where there might be some type of um, application around the eye area. The eye area is sensitive, has very sensitive mucous membranes. So having a physician, an ophthalmologist, evaluate subjects before and after using the product provides another sense of robustness, provides another level of robustness to your safety package, provides you some insight as to how the product's interacting with the eye area. Are you getting irritation? Are you getting any type of corneal involvement or any type of sclera involvement, iris, conjunctiva? These types of uh, um, uh, issues can be problematic. Again, it can be performed on people who wear contact lenses to see if there's any interaction of your product with those individuals that use contacts. Does the product deposit on the contact lens, for example? If people who have sensitive eyes, typically, is this problematic for people who have sensitive eyes, or is it safe for those individuals with sensitive eyes? Additionally, what it allows you to do is, in a lot of cases where you're using products that might be water-based, it allows you to then assess the products after people have used them for, let's say, 2 or 4 weeks, to be able to see if the product has any type of contamination associated with repeated use. Most people should be doing their microbial efficacy, preservative efficacy testing up front, but another safe measure to perform is once the people have completed using the product for the prescribed amount of time, that we take those samples and we look to make sure that there isn't any type of contamination. Many of you have known over the last couple of years, there have been a number of eye area products that have ended up being not having a good preservative system and ended up being contaminated or causing people's eyes to become infected. So by having a physician evaluate the eye area through both the slit lamp exams and visual exams, they can help you determine whether or not your product is safe for the eye area. Another type of testing that's considered for the intimate area is gynecological testing. We do a number of gynecological tests a year, and this is designed to look at how the products interact with the intimate areas, with the vaginal area, looking to see if the product irritates both the external and the internal vaginal tissues. So we have gynecologists who can do the exams to be able to help determine if there's any type of dryness or any redness that's developing. The subjects will be able to provide the responses if there's any burning, stinging, or itching. These products, we do a lot of testing on products designed for the intimate area, and they douches or wand tampons, feminine care products, and just intimate area products in general. These are maybe lotions or gels or things that are designed to be applied to the intimate area. So the gynecological exam can be very useful, especially dealing with tissue that can be somewhat sensitive. One of the other things to consider in testing, and the next slide we'll talk about, is pediatrician tested. There are a number of products now being directed towards marketing for children or for young adults, tweens, teenagers. In fact, there's been some recent publicity of the number of young children or young people who are going to Sephora and Ulta and buying products and using them as part of their skincare regimen. And there's not necessarily a lot of data associated with how these products would be tolerated in younger people. So we have pediatricians who can help you determine the safety profile of your products when tested on young infants as early as 6 months old, all the way up to 17-year-olds. So we have the capability of having pediatricians come in and evaluate the subjects before and after using the product to see if there's any irritation. In those cases, we depend on the parents a lot for younger kids to see if there's been any type of responses that they've noticed, whether it's transient redness or does the child have any type of emotional signal when the products are applied that would indicate that it's uncomfortable for them. So this can be very helpful for you. We do all our pediatrician tested studies using an IRB, given that these are minors. So we have another level of oversight associated with the study. Again, that just makes your safety package more robust if indeed you were to be asked for your safety data. The guidelines that we need to keep in mind are that before we get going there, I just want to again remember that adequate safety substantiation is very important, and it's based on not just formula. It's based on uh, clinical data that you can collect, and that's just not uh, testing on human subjects. But as you'll see in the last bullet point, I'll jump there first. It also includes your micro testing, your stability testing, a review of ingredient list, all of the things that go into making your product safe. So it's great to have a product that is tolerated well in a population, but if you have a product that's not preserved well or is not stable in packaging, then you'll have other issues associated with safety or potentially safety. Now, there is no guidance on what tests need to be performed, and this is I guess typical of the FDA. They may lay out some rules for you, but they don't tell you what to do. So that's where you need to lean into your clinical labs like ALS to help you in determining what makes the best sense based on industry standards and norms. It's one thing to know it's one thing to know that you need to do a test. It's another thing to do the test. So you have to be mindful of that. That just because you think that the product has been out there or that it's been on the market for many years, there is no provision in MoCRA for grandfathering ingredients or products. So all products have to have a safety dossier or safety substantiation if being sold in the U.S. Um, there is no required ingredient safety review by the FDA. This is up to you as the manufacturer, working with your internal colleagues to ensure that the ingredients that you are selecting have a safe profile. But ultimately, you're going to need to test that in some type of human population to be able to understand if indeed the formula is tolerated well. You have to maintain these records for supporting adequate safety substantiation. In case the FDA or some other entity comes and asks you for this information, you'll have it available. If you don't have the safety substantiation data available, it could lead to the product being considered misbranded or adulterated. And in that particular situation, if the FDA determines that your product is misbranded or adulterated, that's basically saying your product is deemed to be unsafe. And that's just not probably a position you want to put yourself in, because that may open you up to other types of litigation that you want to really try to avoid. The FDA now has the ability to recall all products that they deem to be unsafe. If you don't voluntarily take them off the market, they can force the products to be removed. And again, just to remind you that safety is more than just human clinical testing. There's a package that you really need to put together in order to ensure that your product's safe. And the package will depend on the type of product that you're evaluating. I know a lot of people have recently seen the information from aerosols and benzene being a contaminant. You need to know what your product is, and then you need to go to a facility that can help you understand, do you have benzene derivatives? Are you producing emulsions that contain 1,4-dioxane, which is prohibited at certain levels in states like California and Colorado? And you have to remember, the MoCRA does not preempt state laws. States can make their own laws against ingredients. So they can make it more rigorous. They just cannot make it less rigorous than MoCRA. So if states want to institute bans on certain types of ingredients or put limits on certain types of ingredients, like 1,4-dioxane, then you need to be working with a lab that understands that, well, when you're testing an emulsion, this is something you should be looking for, because it is a Prop 69 for California item. And I think Washington just passed legislation regarding PFAS and some of the other types of contaminants that can be found in cosmetic products. So if we move to the next slide, there's just a couple of things to get ready for. We know that initially FDA had registration by dedicated to be completed by the end of the year, and they extended that to July of this year. Make sure you have all the necessary safety files to substantiate the safety of your product. The delay in registration of the facility and ingredient listing did not delay the need to have safety information. That wasn't delayed. So you are required right now to have safety dossier for each of your products supporting the safety substantiation. There are some different rulemaking notifications that will come out regarding talc and fragrance allergen rule, GMP rule, and PFAS rule. These are all designed to come out in the next few years. Don't assume that the legislation will not be enacted upon. My guess is a lot of people may have taken an approach that, that it's the FDA, they're never going to get to it. I don't, it would be terrible if you were the first one to be made an example of. So it's better to have data and to then be criticized for saying, well, you didn't do this, this, and this, but at least you've done something, as opposed to not doing anything. Because what that will open up is that will open up other questions. It will open up, well, if you were manufacturing this particular product, did you do it for other products that you're manufacturing? And then they can then look at other products to see, well, did you have safety substantiation for your other product lines? And I don't know what the downstream effect will be. My guess is it's going to be the retailers will eventually ask you for your safety substantiation dossier, because they don't want to be held liable for selling products that the FDA would consider not to be satisfactorily substantiated for their safety. So it really, and I'm not trying to scare you, I'm just trying to give you some insight as to what possibly can happen. So by being prepared, you will help avoid any future problems, or help reduce any future problems that may arise with the FDA, with competitors, with product litigation attorneys, with people who are looking to try and take advantage of whatever the MoCRA legislation provides. Your clinical testing facilities like ALS can help you substantiate your safety, help you look at your products from a chemistry point of view, from an analytical point of view, from a microbiological point of view, to help you give some insight and build that dossier so that when the FDA does come and ask you for your information, at least you'll have something to show them, and that will be a far better situation to be in than to have nothing. Okay, with that, I'd like to turn the presentation over to my colleague Jacqueline Belomo. Jacqueline, she will talk to you about adverse events, and then at the end of Jacqueline's presentation, we can take any questions you might have.
Thank you so much, Barry. That was so informative and so important for everyone to realize that safety substantiation is already in effect, much like adverse events are in effect as well. And important to know that, safety and these adverse event regulations really do go hand in hand. We're going to talk about a lot of what this means for cosmetics, because believe it or not, adverse events are very frequent in other industries, and you'll hear a lot of people say how cosmetics is not as frequent. But the term adverse event means any negative health related event associated with the use of a cosmetic product. So under MoCRA, before MoCRA, there was no mandatory reporting for adverse events unless it fell under those serious adverse event definitions. So the previous definition for serious adverse events means that an adverse event resulted in or required medical intervention to prevent death or life-threatening experience, inpatient hospitalization, a persistent or significant disability or incapacity, congenital anomaly or birth defect, or an infection. Those are very, very deep terms, especially when you're talking about the use of a cosmetic product. As we've seen in the last, I would say, 5 years, a lot has come to light about cosmetic products, the residuals, the trace amounts of things that are dangerous, and that could potentially result in adverse events and serious adverse events. When MoCRA was, passed, they added provisions to the serious adverse event definition to include conditions that would be seen in the cosmetic sector. So serious persistent rashes or infections, second or third degree burns, significant hair loss, or persistent or significant alteration of appearance. The regulation that is set forth for cosmetics is to protect those who are experiencing adverse events, serious adverse events around cosmetics. Now, you'll hear a lot of people say that my cosmetic is safe. It's been in, it's been in fields for years. I've never had an adverse event reported. You definitely need to take into consideration these additional points that FDA now has to be aware of, and specifically to cosmetic products. They're no longer going to be these consumer complaints, but they will fall under these adverse event situations. First thing that we all have to be aware of is receiving adverse events. So as Barry mentioned, on the label, the responsible person needs to have a way to receive adverse events. And this can be through a domestic address, domestic telephone number, or electronic contact information. Currently, unless FDA provides guidance that would allow more flexibility, this required contact information is going to have to be on the inner container and outer container. So very, very important that your primary and secondary packaging both has this type of contact information. FDA has also made comments about sources of incoming information. So FDA has stated in other industries that companies should anticipate receiving adverse event information through a variety of means, including internet, fax, email, regular mail. As we know with social media, we get lots of comments through Facebook, lots of comments through Instagram. Sometimes we get complaints through Instagram. We get complaints through retailers. So very, very important that not only do you take into consideration the contact information that will be on the label, but how you will manage the incoming sources of information when it comes to adverse events. It can be very daunting on a company who has no current system in place for receiving adverse events, and only is functioning from a consumer complaint side to take on this type of responsibility, because it really needs a specialized person to understand what the event is, the types of questions that have to get asked, the type of record keeping that will go into play. So it really needs someone who is able to designate what is an adverse event, a serious adverse event, and what is summed up to be a consumer complaint. Adverse event record keeping also went into an effect December 29, 2023. So everyone should be managing their record keeping for adverse events. So again, FDA or MoCRA grants FDA permission to request records associated with adverse events during an inspection. Records should include all reports related to records to an adverse event, records of communication with the reporters, records of the responsible person's assessment of the report, hospital doctor relevant laboratory data, critical clinical data. It's, when FDA is looking through an adverse event, their main concern is to see, is this an isolated event with a product, or is this a public health concern that involves multiple products, multiple concerns across different manufacturing facilities? So very important to have very organized data to show how you have kept the communication, the questions that you have asked, and of course, the relevant safety data and testing information that you would have to support that you have adequately substantiated the safety of your product, and that the case in question could be a very much isolated case, right? And this comes through having this record keeping database and system already in place. FDA has not issued any guidance on adverse event record keeping as of yet. This is the best way to guide yourself now into understanding the type of records that should be kept and how to keep them separate from your consumer complaint records. Very important. These are two different types of communications from customers. Now, why are adverse event record keeping why is it so important, right? So because FDA can access all these adverse events, they have to be organized and contain all that necessary information. When FDA comes to you, you can't be scattering around, running to find the proper information, the proper data. You want to have that readily available, and you want to have it per your product. Very important to designate your different tests for your different products, as well as any adverse events that you had come in. Another really important part of this record keeping is companies can detect issues, trends, and patterns of a product to protect against a public health concern or a mandatory recall. The best person to find out if something is going wrong is the person that makes that product. Your company, you want to be the person to find out if there is an issue. You don't want it to be strung along social medias or through FDA. You want to be able to detect these issues at the forefront and kind of control your own situation when it involves any type of concern when a product is in the field. You're also able to expedite serious adverse events with the proper intake and record keeping system. And I say this because FDA is only allowing 15 business days for you to give a serious adverse event. So if you don't have a proper intake system, you might miss a serious adverse event coming in, and you might miss the deadline to give that a serious adverse event report to FDA. You want to also be able to make sure that if it is a serious adverse event, that you're properly communicating to your consumer and to the reporter that you are diligently watching what is going on with your product in the field, and that you are able to control how that investigation starts as well. You're also able to normalize incident rates and predictable events with the use of a specific product. So, the best examples of these I could have is if there's a product that has, certain, exfoliators in them, and you tend to see that they kind of cause some issues in highly sensitive skins, like you're able to come back and reevaluate some of your testing, go back and have those testings if you see there's some type of hypoallergenic issues. Those predictable events really help you kind of get in front of any issues you could potentially have at a larger scale. And then again, you're able to determine acceptable ranges for actionable variations as well. So if you have an adverse event that keeps coming in and there's a slight rash that occurs when first used or when used at a certain with certain other products, you're able to kind of preemptively tell consumers how to use that product properly. You can put on warning statements on your label. So it's a really good way to keep track of all of these in field, right, things that are happening, which brings us to that post-market surveillance tool. Safety testing is the best way to kind of preemptively decide how preemptively show how your product will act when used per the instructions in in public. But that post-market surveillance is a really wide range of who is using your products, right? These are all age ranges. These are people with different types of skin. So it's a great way to evaluate as well any additional safety testing you might need, and any additional parts of the product that might need to be evaluated or changed in order to adjust for that post-market consumer safety piece. Serious adverse event reporting, as mentioned, has to be submitted within 15 days. You also need to submit a copy of the label within the retail packaging with the report. The serious adverse event records also need to be maintained. So highly recommend your intake system of adverse events have a way to separate the adverse events to serious adverse events, because for 1 year after submitting initial report to FDA, you still have to submit any new and material medical information related to that serious adverse event. So very important that you streamline adverse events, serious adverse event reporting, and have those properly documented. This is going to come into huge play, especially when FDA provides a launch date for that electronic submission for serious adverse event reports. We'll go into a little bit detail. Right now, what's happening is FDA has guided industry to submit serious adverse events through the 3500A MedWatch form, which is their current submission. You also can submit via email. And again, this is only for the mandatory reporting. Again, FDA has in other industries explained that 4 minimum data elements are needed when providing a serious adverse event. And this, of course, is a identifiable patient, identifiable reporter, a suspect product, and the serious adverse events. Very important, to go over the MedWatch form if you've not seen it before, so that you can have these questions prepared ahead of time when you're doing an investigation for a serious adverse event. Also understanding the pieces that you'll need as a company to understand. Was the product used in combination with other products? Was the product not used correctly? These are all very key questions that you need to be asking under an investigation to make sure that your company in part might not be to blame for why an adverse event happened, and again why you need to kind of protect yourself as a company with these types of documentation and record keeping. Overall, adverse event reports are not construed as admission that the product in question caused or contributed to an adverse event. This is what this investigation process helps kind of alleviate and helps determine. You can even, with an adverse event submission, you may even include a statement denying that the product involved contributed to an adverse event. So very important that if you're undergoing an investigation and you have 15 days is up, that you can actually submit a statement that your investigation up to this point has proven that it was not the product that contributed to those adverse events. Serious and unexpected adverse events are rare in cosmetics, as we have said before, but the company should always notify FDA of any known serious or unexpected adverse events. We've been seeing this a lot more in industry, that FDA is becoming a lot more involved with legal litigations and personal class action suits that are happening around industry. FDA does need to step up sometimes, or needs to step up and make the comment when it's something as predominantly of what we've been seeing happening on the cosmetic sector. Very important to note, though, the FDA has made adverse event reports public. So very important to understand what's public and not public. So anything personally identifiable information is not going to be available or disclosed or distributed without any type of written consent. And then under MoCRA, serious adverse event reports submitted to FDA are protected as records. So anything that falls under those FDA protection of records, so anything with a child under the age of 5 or a minor without a parent's signature, those all constitute under those reports that are protected under FDA. So we get a lot of questions about how can they make this so public, if there's an investigation, everything going on. So it is FDA's responsibility to make sure that the public is protected. protected against anything that could potentially cause these health consequences. So under MoCRA, Mandatory Recall Authority, FDA is able to issue a mandatory recall. If there is a reasonable probability that a cosmetic is adulterated or misbranded, or the use of exposure of the cosmetic product will cause a serious adverse health consequence. The responsible person is going to have an opportunity to voluntarily cease, but if they do not, the FDA is allowed to issue a mandatory recall. There's 3 classes of recalls that are currently under 21 CFR Part 7. So you'll have your Class 1, your Class 2, and your Class 3. And these are all relevant to the probability or exposure to the product, and how that product will either cause or temporarily cause any medical issues and adverse health concerns. Over the course of the last few years, cosmetics has been in the news due to a lot of the personal recall, or the companies recalling products on their own and taking in hands of what they feel will protect their brand and protect their product integrity. So that is like a really important piece that you need to consider when reviewing your safety information, reviewing your adverse event information, and now the potential that it could be recalled by the FDA. But it's important that, again, you understand where FDA has authority and what that means to your company. So again, inspections and record access, they're going to have the ability to pull all of that information that has to do with a adverse event, especially if they have a reasonable belief that the cosmetic product or the ingredient is likely to be adulterated, and that exposure is going to cause or present a threat of a serious adverse event, consequence, or death. All these records are going to be accessed by those authorized agents from FDA. They may even request a list of ingredients in a product's fragrances or flavors that may have contributed to a serious adverse event. This June, we hope to see a proposed rulemaking on fragrance allergens from FDA. So those are going to be included in this record access ability from FDA. And then again, record access does not include any cosmetic formulations or recipes, research data, other than safety, of course, and no financial data or shipment data, pricing data. This is solely to see if specific safety substantiation data has been done, if you have properly maintained your adverse event records, that you have reviewed your adverse event records to make sure that there is no issues or threats that you have been seen with the use of a product. Now, how to prepare? Again, we are already in we're already in adverse events receiving, so you should be receiving adverse events, but make sure you understand who should be listed on the label as the responsible person. The responsible person, again, is not a person, but a manufacturer, packer, or distributor. Determine if you'll be using a domestic address, domestic phone number, or electronic contact. The importance of the receiving that the contact be checked daily. If using a domestic address, it should be the responsible person's full U.S. mailing address. And then electronic contact is very new to adverse events. This has not been done in any other drug or dietary supplement sector. So it's the first time FDA will be giving guidance on its interpretation of electronic contact information. Being at a lot of FDA symposiums and seminars, it's been very clear this electronic contact information should be exclusive to receiving adverse events. This should not be a website that brings you to products. It should be a website that brings you to a place that a consumer can put in their adverse event so that it can report to the responsible person. The email, as same, it should go to a person that's able to evaluate the adverse event and determine next steps. Again, cosmetics with small packaging or limited space, consider where to place this contact information as well. And then companies should plan to have adverse event reporting coming from a variety of sources and implement a system that is designed to recognize adverse event reports and route the information correctly to the appropriate person or team. Registrar Corp right now, we are offering a lot of help around adverse events. We've created a software solution that creates URL codes that you can use to take consumers right to a reporting page. There are, call centers out there, but make sure whatever it is that you do, you make sure to implemented soon, because these are in effect. And serious adverse event reporting, again, make sure you have someone who is able to handle reporting and submitting reports to FDA that has experience in doing so. Anyone who has not touched a MedWatch form or has reported anything to FDA previously might have a lot of issues, and timing here is crucial. So make sure to set up your SOPs to monitor and investigate adverse event reports, timelines and process for measuring whether the event is reportable to FDA, and then timelines and process for reporting new information to FDA, and then update any policies to reflect these new requirements. Lastly, our beautiful MoCRA timeline you'll be getting in yours, you'll be seeing in our recording. It just shows you all of the key dates, everything you need to be proposed rulemaking, final rulemaking, and when to be looking out for these regulations. And lastly, I would love to tell you that ALS and Registrar Corp are going to be both at In Cosmetics Global in Paris and also Suppliers Day in New York. So please stop by our booth. We'd love to see you there. And we would love to open the floor up to questions that everyone has happily put into our chat. So I'd like to welcome back Barry and Anna so that we can start to get some of these questions answered for you guys.
Thank you, Jacqueline. This is Anna, and I want to thank you and Barry for such an informative presentation. A lot of just really important information that cosmetic and personal care product companies need to be aware of. And so, yeah, let's go ahead and open it up to some questions. So we've already got some questions in the Q&A that you see at the bottom of your screen, but do feel free to add if you have any. And I'll go ahead and start with the first one, which is a question regarding, sorry, it's in Spanish. Give me a second. So it looks like the question is about post-consumer product safety tests being carried out. And maybe Barry, you can just elaborate a bit on that.
I'm not sure what they're referring to, but if they're referring to assessing safety once the product is on the market, then I don't think that adheres to the spirit of the MoCRA legislation. The idea is to document the safety of the product before it is marketed, so that any untoward products or any products inducing any type of intolerability will not go forward. The post-marketing, I think that's where the adverse events and the interaction with the manufacturer comes in, and being able to report if there are issues associated with using the product. But I don't think the FDA would look at the post-marketing assessment solely as a means of determining safety. I think it depends, because it's not done under controlled conditions. I would suggest that that particular individual check with their regulatory people, but that they, to the best of their ability, should perform these types of safety substantiation tests prior to marketing the product.
Fantastic. Thank you very much. Okay, our next question is, how does a wholesale distributor who is just using a manufacturing company to put their name on the label, a private label distributor, and the product is drop shipped directly to a buying customer, comply with having safety substantiation information on the products, and who reports the adverse events, the actual manufacturer or the private label distributor? Barry or Jacqueline, either one of you, or both of you take on that one?
Well, I think from the safety perspective, it's the responsible party, and that's where it's defined. Who's the responsible party? If it's the person who's having the contract manufacturer develop the product and then drop ship it, the responsible party is probably going to be the individual who contracted the manufacturer. It's going to be in their name. It's going to be their product. They have to recognize that. I spoke with a litigation attorney who's a friend of mine, and he said that typically in these types of situations, there's going to be two questions asked of you about safety substantiation. The first question is, did you know about the requirement for safety substantiation? The second requirement that will be asked is, should you have known? And if you answer yes to either one of those, then I think the liability would be with the person who's producing the product to be sold. So your contract manufacturer may require you to do that as part of, maybe they look at it as a way to protect their business from any potential litigation or involvement with the FDA. But I would say that it's the responsible person's party, and whoever that is, that's the person who will have to maintain the safety dossier.
Okay, great. Thank
Jacqueline,
you. Sorry, go ahead.
I was going to Jacqueline may have something to add to that.
No, I think that's exactly the right approach to it. It's very important that the person on the label knows exactly the responsibilities that they're going to have to handle, with safety being one of them. So I think you covered that pretty well, Barry.
Thank you.
Okay, great. And I think the next question actually kind of ties into that, asking whether beauty brands need to have a third-party call line on the packaging to report adverse events, or are they able to include their own brand? Again, it goes back to that responsible person definition that Barry highlighted early in the presentation. Whoever's named on the label as the manufacturer, packer, distributor is the one that's going to be have to be the contact for this. And you can rely on either the electronic contact, a domestic US phone number, or a domestic US address to meet that requirement. Okay, and then next question, are there any regulatory requirements for cosmetics regarding the skin microbiome?
No, there's no regulations associated with it. There are procedures you can perform with people to determine if your product is disrupting the microbiome. And there's things you can do to where you can measure things like the Shannon index to look at the distribution and evenness of your microbiome before and after treatment. But there are no regulations associated with it. There is guidance that has been put out by the PCPC regarding how to approach microbiome testing, but there is no legislation that I'm aware of that actually dictates about microbiome. But there are good tests that you can perform to help understand how your product is impacting the microbiome of the participants or the users of your product.
Okay, great. Thank you. Then we have another question. What is the best advice for smaller brands that don't have someone internally that can handle adverse reaction correspondence?
I'll take that one. So, there's several ways you can handle that. One would be obviously to hire someone internally to take over these adverse event reports. But if that's not something that you internally can handle for various reasons for small teams, then I highly recommend hiring a third party such as Registrar Corp. There's several others out there that can help you either with a software solution to take in these adverse events, or to actually monitor the adverse events for you. So if you don't have that type of skill in-house, it's highly recommended that you reach out to a third party to help. One, to make sure you have a system set in place that can quickly get these adverse events to the right person, the right team, and then also be evaluated at the same time. Smaller brands, I think this is going to probably be one of the more complicated pieces of MoCRA, just because it does require a certain skill set in order to evaluate, to report, and to maintain these type of records. But there are lots of solutions out there, and be happy if you want to contact me after what we could walk through, what we are currently offering.
Okay, great. Thank you. Next question is, what is the fragrance allergen rule?
Oh, that is a great question. So right now, Barry, I'll take it because I love fragrance allergens. But currently, there is no fragrance allergen rule under FDA. California itself has adopted fragrance allergen labeling, and then also now reporting, which heavily follows the EU regulations for fragrance allergens. The proposed rulemaking for fragrance allergen is due by FDA June 29th, 2024. So we hope to see a proposed list of what fragrance allergens will be required to be put on the label. And now this will be also the thresholds and the uses. So leave-on, rinse-offs, and then the threshold of the percentage of the fragrance inside the formulation. Very important to note, fragrance allergens are not only found in fragrances, but they are also found in flavors, and they're also found in essential oils and many, many other extracts that we use frequently in our cosmetic products. So be aware when you hear fragrance, it doesn't just live in fragrances. There's going to be other pieces of your formula, other ingredients of your formulation that are going to be need to be evaluated to see if they have these type of allergens present in their composition.
Okay, great. Thank you. Next question is, just to confirm, the only information that we need to add to the label to comply is the responsible person contact.
I'm sorry, say that one more time, Anna.
Sure. Just to confirm, the only information that we need to add to the label to comply is the, quote, responsible person contact, unquote.
Well, so technically there's 3 different labeling regulations that are in effect for MoCRA. So you have the responsible person that has to be on the label, and the contact information to receive an adverse event. So that's one. The second is if you have a professional product, professional use labeling has to go, is also in effect currently right now. So any professional product should have an updated label to have a clear and prominent statement that it is a professional product. And then lastly, those fragrant allergens will also be required for an updated label. So you have 3 different labeling updates that have to occur, but specifically for adverse events, you just need the responsible person contact to receive those adverse events.
Okay, great. Next question, what is the process for registering a product and how long does it take?
I'm going to assume they mean registering the product in the portal. So the portal is open. You can go in and register or list your products and register your facility. Very important to note that facility registration has to be done before a product listing. So FEI numbers, responsible person, product categories, all have to be done by the facility first before a product listing should be done. So if you have your own manufacturing facility, it's probably a lot easier for you to do. If you do not, you should be reaching out to your contract manufacturers and seeing where they are in the process, if they have their FEI numbers, and if they have already started their registration, and how it applies to your products.
Okay, thank you. Next question, is SDS documentation considered a safety validation source?
No. I mean, that certainly is it can be a piece of it, but that's not in and of itself going to be a safety evaluation source. Again, I'll just go back to the definition of what they had determined to be safe, and ultimately, it's looking at the product, how it's intended to be used. So that's really going to drive how people assess the safety of their product. You need to evaluate it in a population of people under the conditions that are described on the label or that you are wanting them to use when the product is marketed. So that by itself is not going to provide it. Again, safety assessment or safety dossier is a robust document that should contain, as I mentioned, not only safety testing from the clinical perspective, human clinical perspective, but microbiology, any type of microbiology stability or chemistry that needed to be performed as well. That represents really the safety package. If your product fails microbiology, really doesn't matter how well it would be used in, or how well tolerated it would be used in the public. It gets contaminated, so it wouldn't be considered a product that you would want to apply to the skin and risk an infection or something occurring. And as Jacqueline said, the FDA has changed the rules for or the definitions for serious adverse events, and one of those is infections. If somebody is deemed to get an infection or have an infection due to the use of your product, that's a serious adverse event, and it requires a different type of reporting structure than non-serious adverse event. I don't know if that answered your question, but I guess the answer would be no.
Thank you, Barry. Got another similar question. Would Europeans' CPSRs be considered sufficient as proof of safety substantiation?
They could be, yes, they could be. And there are countries like Europe and China that do a lot of testing, and actually, the U.S. is behind our colleagues in Europe and Asia in this respect. So yes, that could be seen as an appropriate document to substantiate the safety of your product.
Okay, great. And next question, can stability testing be lifted and based on the number of years the products have been on the market without any issue?
I don't understand the question.
I think the question is whether stability testing is necessary if it's been on the market for a number of years without any issues.
Uh, um, Well, I would always say yes, because the stability testing is just not done um, at room temperature. There's accelerated stability testing, which is done at elevated temperatures to try to determine how well your product performs, not just at room temperature, but at temperatures that might be elevated that would reflect maybe the product being in your car or the product being in a warmer environment. So I don't think that just having a product on the shelf without any true stability data would um, reflect the true stability profile of the product. You really need to speak with a clinical lab like ALS that has stability experts that can give you some idea of what would be considered appropriate for your product. And remember, there are also, depending on if your product has actives, what that active does it degrade over time, and that's part of your stability. So if you have, let's say, salicylic acid in an acne product, is it degrading over time? And if so, you need to be aware of that. Or if there are other types of chemicals being developed as a result of the degradation, you need to be aware of that as well.
Okay, great. Thank you, Barry. So we have a question that I think some other people, a scenario that other people may have encountered. For a soap to sell on Amazon, Amazon asked for these documents: the FDA Voluntary Cosmetic Registration Program Form 2511 and the Cosmetic Product Ingredient Statement Form 2512. Any insights on how to get these documents?
No, I'm not familiar. I'm not familiar with those. I'm not familiar with the Amazon documents that they're requesting, so I don't have any
Yeah.
insight into that.
Yes.
Maybe Jacqueline does.
Yeah, so Amazon is basically it's following suit to making sure they're protecting the consumers, that there's proper testing that goes on, that they're not um, you know, counterfeit products. Like they want to make sure everything that's being sold through Amazon, especially in the cosmetic space, is been tested. So safety documents are going to be required on Amazon, but Amazon has a completely different way of set requirements, I would say, than the FDA. So I would definitely just look through their specific document requests and see what they're asking for, and see which safety tests need to be done or would align with what their requests are.
Yeah, thank you. I'll chime in on this one too, because the FDA's Voluntary Cosmetic Registration Program doesn't actually exist anymore because of the new MoCRA registration and listing requirements. And so for anybody who's being requested these documents from Amazon, not so much the safety substantiation, but the VCRP documents, you may want to communicate to Amazon that that program is actually no longer accepting registrations or product listings, and maybe assert that you're following the new mandatory registration and listing requirements under MoCRA, and see whether or not they can find that acceptable too. Okay. See, well, we're running over a little bit. Go ahead and try for one more question. Let's see, can you register register more than one formula for the same product due to different fragrance oils with the same scent but different allergen declarations?
Great question. So Registrar Corp has been in the portal for for a few months now, and been communicating with FDA. So the flexible listing that we were told would be possible through the portal is not exactly as cut and dry as a flexible listing. Basically, you can enter a formulation in and clone the formulation to be in the same formulation, but you still need to update the fragrance part or the color part or the quantity part and have an individual product listing for each formulation, even if they differ in fragrance. So say you have a product that is a body wash and one's mango and one's cherry, you need to have two separate product listings in the portal, and both product listings have to have separate numbers. The whole idea of the flexible listing was just so that the ability to clone ingredients, but you still need to update the product name, update the listing. So unfortunately, it's not as cut and dry of I have a body wash with 10 different fragrances, and it gets one product listing. 10 fragrances yields 10 different product listings. So that's part one. And then part two would be each individual fragrance that's used would have each individual fragrance allergen. Right now, FDA has not said anything about being able to do may contains for fragrance allergens. So I would just prep yourselves into having to designate the different fragrance allergens on the label specific to the fragrance used in that product. I probably ruined a lot of people's days by sharing that information, but very important because we've had a lot of people come and say, I have a flexible listing, and not realizing that the portal was not really built that way, that each product, fragrance, shade needs quantity, needs its own product listing number. So very, very important information to give up to everybody. So those allergens will be with its own fragrance and its own listing.
Okay, great. Thank you. It definitely sounds like it's more complex than we were originally sort of led to believe, more in the lines of the complexity of a drug listing. So thank you very much, Jacqueline, for that information. And with that, we're going to have to go ahead and conclude our webinar. On behalf of ALS and Registrar Corp, thank you very much for joining us today. And please don't hesitate to reach out to us if we can assist you in any way. Thank you and have a great rest of your day.